My name is Suzanne Clark. I'm with Beasley Allen Law Firm, Mass Torts Discovery Counsel, and today we're going to be talking about mobile devices, owning the data, owning the case. We found as a panel that this is a very complex and contentious topic, so we're ready to dive right in. What you're going to learn today, our takeaways, are the mobile device discovery options, preservation, collection, production. What are your options for mobile device discovery? You'll also take away the right approach that you can take with these mobile devices, what's right for your case, and then how to negotiate scope with opposing counsel. Bill said we're not introducing ourselves, even though I prepared a really nice introduction for each of our panelists. I do want you to know these are experts. I added it up, and we have over 100 years of experience if you add up all our experience together. But please check everybody out on the app. We've got people from all across the country here that are experts in this field. So thank you so much for joining us online and in person at University of Florida Levin College of Law, my alma mater. Happy to be here today. Okay, what this panel is and is not. Again, as Kelly Twigger so aptly put it this morning, these are our opinions, not the opinions of our employers. Also, we're here to educate, not advocate. We're not trying to advocate for a particular type of mobile device collection. There's no single right way to do this. Every case needs a case-by-case analysis. What we want you to do is, like I said, take away the options that you have, learn about what those are, and then be able to apply them to your case. As Dawson Horn did this earlier today, we are going to apologize to the forensic experts in the audience. But what we'd like is for everybody to be able to walk away, everybody online and in person, to be able to walk away, no matter where you are practicing in the EDRM, to walk away and understand mobile devices enough to know how to apply it to your case. Also, as I said, this can be a contentious topic, and our panelists did have divergent viewpoints, and we think that helps with learning, and so we are going to debate a bit and argue, but walk away friends at the end. So with that, let's dive right in and talk about why mobile device ESI is different. So Michelle, can you start us off?
Sure. So one of the ways in which mobile device data is very different than other types of ESI is that it's unique. So what we mean by that is that some data is only available from the device itself. Examples of this can include messages, photos, videos, and notes when they're not synced or otherwise backed up. And that actually probably happens more often than you may realize. Other data that's only available on the device is things like voicemail, Signal, Telegram, WhatsApp messages, WeChat, location data, device usage information, and browser history. So when we say unique, we mean that kind of information that you really only can get from that one place.
Great. And John, can you talk about some unique preservation challenges you've come across?
Well, one of the challenges with mobile, unlike maybe a laptop or desktop, is that they're portable, they're fragile. They have certain encrypted states that you don't see on a computer, and those can shift at any time when people don't expect it, which means it's difficult to get to the data. And you have things like they get lost, they get stolen, they get dropped in a lake, wherever. So those are unique challenges that we don't have in, other fixed endpoints that we're working with.
Great. Sean, talk a little bit about ubiquity. That was the big vocabulary word you used on our panel prep session.
So when Bill introduced our topic just a few minutes ago, I mean, he kind of alluded to this. We are all familiar with the consumer experience. We are familiar with the kinds of data that are on our phone. We know how to access it. We know what it looks like. And that data, the things that we're familiar with, that personal experience, knowing how we interact with it, is very different once we get to the courtroom. It goes from something that is live, it's personal, it's interactive, and then it becomes something static, and it can look a little bit different. And I think that has a pretty big impact because your clients, litigants, also have that same personal experience. And they may be familiar with a PDF document or a Word document. And it's true that there are some hidden complexities with that. But with mobile data in particular, the extent of the complexity, the things that we can't see behind that consumer experience, are much greater than other kinds of file types that we're going to be working with.
All right, great. Thank you for that. And Matt, can you talk about some complexity issues with mobile data?
So the operating system on your mobile phone is much more complex than it would be from a laptop, right? Or from O365, M365 environment. So if I was looking for an email between me and Suzanne, that's much easier to query that system, find that data, and return that data back. These systems, the file operating system is much different. It's very interconnected. So using like your text messages as an example, that database doesn't store your friendly name, right? That's stored in a contacts database. And so there's a lot of these databases, there's a lot of parts that are talking to each other. And so when we're trying to concatenate all that information into kind of a singular source of truth, there's a lot of different things to be taking into account there.
Okay, great. That's a great intro. So moving on, Michelle, we have a lot of tensions that drive mobile device discovery disputes, and we've listed them here. Can you talk to us a little bit about the idea of privacy and how that can lead to disputes and risk and tensions in mobile device data discovery?
Sure. So one of the most common tensions I think that comes up when we talk about mobile devices, and that does tend to lead to a lot of disputes, is over privacy. On the one hand, mobile devices really do contain an inordinate amount of personal data that is not usually relevant to the litigation. Banking applications, health-related information, passwords, communications with family and friends, photos of children, things like that. None of that is typically relevant. But on the other hand, mobile devices often do contain information that's relevant to the litigation. Text messages with work colleagues, call logs, voicemail, photos, notes, and even location data may be relevant. And the federal rules do favor liberal discovery of relevant non-privileged information when it's proportional to the needs of the case, while privacy is not actually an independent limitation on the scope of permissible discovery. So we have that kind of at play in the background. Where privacy does tend to come into play is through a proportionality analysis, namely whether the burden or expense of the proposed discovery outweighs its likely benefit. But even that's just one of the 6 factors bearing on proportionality. And then it can also come into play through a protective order, which allows courts to limit the scope of discovery to protect a person from undue burden or harassment and things like that. So while I think it's very important to think about privacy with respect to mobile data, privacy concerns should really not operate as like a categorical bar on discovery. Instead, parties should really consider how best to handle private or sensitive information so that they can still ensure that the relevant information on the device is reasonably identified, collected, and produced. This is probably going to require some difficult conversations at times and maybe management of expectations with clients and custodians. But there's other things that parties can also do to address this. They may be able to negotiate the scope of relevant discovery to identify certain private information that is just really outside the scope, and there are ways that can be targeted through collections and searching so that it can be excluded. But that really requires the parties kind of having a real discussion about these issues. And then it may also be addressed through protective orders too, which can limit the scope and disclosure of private information. But I think the overriding point here is that mobile devices shouldn't be sort of categorically excluded from discovery considerations simply because they may contain personal private information. I think those issues need to be identified and addressed.
All right, great. And then Sean, the tension that arises from mobile devices being dual-use devices.
Yeah, so we heard about that a little bit this morning during the discussion about the possession, custody, and control. And this is a problem in all kinds of cases where we do have a lot of that intermixing, okay? And that intermixing happens because our phones are typically like the most personal devices we have. We feel comfortable sitting in our living room talking to ChatGPT and asking it questions that may or may not be privileged. And so because of the information they contain, how we use them, how we're comfortable with them, we often end up in a place like this, okay? And you can, in some respects, interchange personal and business with relevant and non-relevant. I might have really key text messages or signal messages about a particular topic, but I also might have, pictures from my kid's t-ball game. What do you do? And this is one of those areas where, in my experience, I don't have a one-size-fits-all answer. But what I will say about it is that this is where the fun happens. This is where we get to be a little bit creative with how we approach this complexity that comes out of these dual-use devices. Okay, and I think again, at least in my experience, sometimes there's a lot of focus about talking about a problem. Okay, and I think the reason for that is problems are easier to identify. They're easier to articulate. But it's in coming up with the solutions and being creative. That's where the magic happens. That's where you can come to something. Come to an agreement, or kind of weigh things out carefully so that it can be carefully measured. And it's just going to give you a better result. And in my experience, I found that it has made. There are ways to make everybody happy.
Good. We'll learn more about that as we go. Matt, can you talk to us about some outsized consequences?
Sure.
Yeah.
My favorite
some
thing
horror
to talk
stories.
about. Yeah. So we said small decisions, big impact. I know there's lots of people out there that think we'll get to the smartphones later, right? There's private data, so we're kind of getting into when does data preservation need to come into play, and we'll kind of get into that here in a little bit. But these small decisions of do we preserve it now or not carries big consequences, right? I know lots of us in the room have the horror stories of someone not disclosing they had a phone and we have to get a judge's order to produce it quickly. Or there's a mass amount of custodians that are across different states, and that's a very big kind of undertaking to get to. And so when we're dealing with a shortened timeline for those things, that carries a pretty big financial cost. There's legal risk. Right, and so like I have a client that had SEC compliance regulations, and they needed to be monitoring texts off their client's phone. They were going to be in front of the SEC as I don't know if they were presenting on something, but they were out of compliance because they weren't collecting iMessage off of these phones. And so we had to do 318 phones in 2 weeks, right? And then for all the people that are in the room that have all done this before, we know that's very expensive. That almost feels impossible. And so it's kind of an interesting conversation here of text messages or WhatsApp messages feel like such a small part of this case, but if they're not treated early enough or assessed early enough, they carry big financial risks.
How did you manage to get 318 phones in 2 weeks? A lot of people.
A lot. No, actually, we got it done with 3 people. It was pretty awesome. So, yeah, but it's just, the scale of what is happening now. A lot of federal regulators are now saying that we know these conversations are happening on phones. You can't just not assess that data anymore. And so just the scale of what we're having to kind of look at and assess and do that is growing exponentially for sure.
Okay, great. So what we want to do now is talk about what are our options, because I know in case law you'll see you have to do an image of the phone. What does that even mean? And let's just get started going through the different types of collection that you can do with mobile. And Sean, we'll start with you. Can you talk to us about a full file system extraction and what that is?
Sure. So a full file system extraction, again, we call it an extraction when it comes to phones. We typically don't refer to forensic copies of phones as images, just because the term image has a connotation with it that, hey, this is a bit for bit from the start to the beginning, including all data here. That is just not the case with phones. And so what a full file system extraction is as near or as complete as possible forensic copy of data from a mobile device. So notice I did not say that it's complete. Okay, it's not necessarily everything start to finish, but it's the most that we can possibly get from a device. So in contrast to some of the other extraction methods, those other extraction methods, the way I like to think of it is there's like a bar bouncer. Okay, the bar bouncer is the phone, it's the operating system, it's the app. And the bar bouncer says, okay, for when I make an extraction, only you can come in, WhatsApp messages, normal text messages, fill in the blank. With a full file system extraction, we don't have that intermediary. I don't have a bar bouncer. When I say, give me a copy of this data, as much as possible comes to me. And so in that respect, it's pretty complete. So what kinds of things do you get? Okay, I think that would be my question.
Right.
You can get additional location information. Okay, you get more of it, and sometimes for a longer period of time. So to the extent you're dealing with a case where location information is important, especially for folks in corporate, like if you assign corporate phones and you have somebody leave under suspicious circumstances, or all of a sudden you're losing projects, that GPS information might show you that, hey, when this person said they were on vacation, they were actually in town and walking over to the competitor's office across the street. So it's one of those things that, you just have to think outside the box every now and again. You can also get device usage information, okay? And this can be really important in a lot of personal injury cases, things like traffic accidents, to know the timing and whether things like phone unlocks happen, or what app is open at a particular time, or the amount of time that it gets used, when the display gets turned on. And so you can get some of that. The third thing that you can get is sometimes you can get deleted information. And I want to explain here that you can't always get like a deleted text message, okay? You can't always recover it just because of some of those hidden processes that we can't necessarily see when we're using a phone. But I'll often find deleted messages. So what the heck do I mean by that? Okay, someone may delete a text, and when we go and we look at the phone, we don't see it there in the normal text database, okay? It's gone, can't find it. But with a full file system extraction, because it includes some of that system information, there may be a message that has since been deleted, okay, in something like one of those system logs, or the databases that keep track of notifications. And I had a really big case in Minnesota that did receive some national attention, and that was exactly what happened. There was a disappearing signal message that contained a video of an alleged crime that was being committed in this video. The message disappeared, it was deleted. But because we got that full file system extraction, we were able to find in these databases that can record what the notification was, a copy of this deleted message. So that's a long way of trying to explain to you that a full file system extraction is really just a method for getting a copy of a phone that's as complete as it possibly can be.
Okay, thank you, Sean. Now, John, will you talk to us about logical image? And I don't know if image is the right nomenclature, but talk to us about this idea of a logical collection of a phone, which is different than a full file system, and how is it different?
Yeah, and so it's kind of a perfect segue because to me, there's two different levels. People try to say logical or physical or image. I think it really comes down to two things. There's standard access, which I'm going to talk to you about instead of logical. And there's elevated access, which is everything that Sean just awesomely described, right? And so these are two completely different approaches that gives you different sets of data. So let's talk about logical. Number one, that is just not a great term for mobile data collections. So we're going to talk about a standard access. What does that mean? That means we're using something like iTunes for a backup, and we're using an Android backup program. These are basically the default supported processes for the operating system. So Apple says, okay, I'm okay with iTunes, or Android has what's called ADB, which is the way that you get data off of it. Why does that matter? It's because it still gives you a lot. In a standard civil litigation, what are you after? What do you want? You want messages, you want contacts, call logs, voicemail, voice notes, some other messaging apps, videos, pictures, right? How many of those things check a lot of the boxes that you would want if you were, you were trying to do a collection on a mobile, right? I mean, it handles a lot of stuff. And so logical, those applications which use these standard backup procedures are less evasive, they're more straightforward, and they're more cost effective. And is it always the solution? No, but we're going to talk about scope. We're going to talk about what you're really after and the feasibility. Things like what we talk about in a logical, or what we call the standard access, they can download those apps and run them locally. They can do it remotely. You can do it for a fraction of the cost and yet still make it defensible. But like Sean said, are you after artifacts, right? Are you after those things that might have been removed from the primary iMessage database, and then it might exist in another database or a cache, or images that are gone could potentially show up in some of these other cache files where that app stored it there temporarily, and even though they deleted it, then you can go over there and get it, right? And so logical is what you would think of in those more straightforward, supported by the OSs, get a backup, and then grab all these different common user sources from that backup.
Okay, thank you for that explanation. And we're going to get into when you need which kind of collection later in the presentation, but we just want to make sure everybody's understanding exactly the options available. Now, I think, Judge Ardeglair, you have a question?
Yeah, there's an online question that's getting some traction, and it has to do probably more than just an investigative stage or a preservation stage. It goes beyond that because it's asking about the privacy setting on the phone. And the question is, I noticed on my phone that there are a full section entitled Privacy Settings. How can I protect myself from a discovery request using privacy sections? And then, I know that was a part that it was interesting. The other side of the question is, how can I get data that's been labeled private by the person who's using the phone? Okay, so, I mean, let's say it's an employee that's, that's got this and it's got a privacy setting that's a stop sign.
We're going to need the rest of the afternoon. Can we pick some of these? The attorneys are the ones to
oh, no, I don't think so. I don't know. I mean, if we're talking about the technological aspect of privacy settings.
I can
okay, go ahead, Matt.
So the phones don't have a good way of tagging data as business or personal. There are phones now that are running dual SIM. So you could have a work profile, a personal profile. There are ways to kind of sift through those. Did the employee use the work profile to text someone personally? Odds that there's some cross-contamination can happen. This is also kind of a good segue into the targeted side of collections here. There are workflows and technology now that we can better define what is relevant and what is private, right? So we can do that with identifying what apps we want to pull from. We can identify that through naming participants we either want to include or exclude. And so those are some ways that we can, if I've got a text message database and I've got work and personal commingled, there are some effective ways for us to segregate those together. But your phone is not going to say, this conversation was private, this was not, and exclude those. The OSs are just not built that way. So we need to use some of these options that we're going through right now to be intelligently talking to that data to then sift through what is personal, what is professional or work related. So that's how we kind of approach it. We get that question a lot for sure because everyone thinks that the phone's going to tag that, but it doesn't.
Well, and it's all going to depend on the corporate policy. I mean, I've talked to people helping them get collections put together, and we'll say, well, are you going to target it? You're going to try to grab everything? And we'll say, there's personal stuff. And I've had people respond almost like reflex go, they sign the form. If they want to work for us, we have it. We own it. It doesn't matter if it's the corporate provided device or it's their own device. They're going to agree to it, and if we take it, we want to take it. Well, that's not, that kind of is unnerving, but I've heard that on multiple occasions. Of course, there's places where GDPR kick in, and there's other companies that are probably more relaxed, but this is a thing, and this is one of the key issues is what's private? What can we take? And that needs to be a part of those initial meetings, meet and confers, and defining scope is, what does the landscape look like? What privacy is expected in that particular matter?
I know that usually when I'm dealing with mobile devices, I'm talking to my clients and I'm getting the passcode, and we aren't really having any access issues because they understand they're part of a litigation and they're going to be obligated to produce for their attorneys to review the information. And at that point, I say, if it's not relevant, we're not going to send it to the other side, only if it's responsive and proportional and not privileged. So this question from the audience is mentioning, and this is where I call in my forensic partners, is asking about an actual user of a device putting a privacy setting in place. Now, if you have the person's passcode, I think you can usurp that, right, Sean?
Yeah, that's right. I mean, if I have physical access to that phone and it's provided to me as part of a litigation, and I also have the code, those settings aren't really going to affect the availability of data from that phone too much. It may, just on my technical side, give me a couple of additional hurdles. The one that I have in mind is stolen device protection. That can change the calculus as far as what I need to do to collect it. But yeah, most of those privacy settings, particularly if we're trying to get a logical or full file system extraction, one of these more complete extractions, there's not really granularity as far as hiding data. I mean, if you look at your photos library and you choose some pictures to hide, with a full file system extraction, we're still going to get all of that. Makes no difference. So,
and just because this was getting traction online, I want to dive in a little deeper since there's interest here. What is the purpose of these privacy settings? It's not for litigation.
Yeah, generally not. I mean, the purpose of the privacy settings is to give you, the consumer, some control, some control over where your data is going and what happens with it and what apps are allowed to do on your phone. I think that's a good thing to have, as a consumer, to be able to make those choices for yourselves.
Okay, thank you. Yeah. Now, Matt, will you talk to us a little bit about targeted collection of mobile devices? I know people talk about defensible collections, forensic collections, targeted collections, and that can be one thing for email if you're targeting date ranges and such as that. But we're talking about something different here. So can you talk to us about what that means?
Sure.
Thank you.
Yeah, so think about this as logical plus, I guess. This is a good conversation we just had about this, right? Being able to look at the data that's available and sift through, again, what is personal, what is private versus what is relevant or in scope. That does take a little bit more dialogue on the meet and confers or custodian interviews about what we're looking for, where that data is stored. But being able to take these collections one step further, right? So John was saying that I hear this from corporate clients, like it's a corporately owned device, we're entitled to everything. But there's a lot of corporations today who are also kind of maturing what data they want to be retaining, what they're preserving, just because there is risk for storing personal data, long term. There's a lot of different risks there. So being able to take some of these abilities to target by an app, by a date range, like I mentioned earlier, target by a phone number or exclude a phone number, really helps us hone in what that potentially relevant data set is, and then be able to use that to then build our case from. Today, these phones are a terabyte large, and if you're a soccer parent and you've got 9,000 photos of your kids, that can take a lot of time to collect, transfer from the phone to a media that you're writing to. And so being able to use technology to then take those a couple layers deeper and target that relevant data set really helps us mitigate costs, mitigate speed, be able to do these things a little bit more remotely. So that's just kind of a good workflow to be applying for sure.
Okay, and we'll get more into FFS versus targeted later in the presentation, but I think we have another question.
Yeah, this is another online question. Are you able to identify messages that were edited and what edits were made?
I can take this one too.
Okay, you go.
So let's use, Apple is where the edited messages come from. So your phone actually stores those edited messages in additional fields and then encrypts that. So when we can pull the SMS database or things like that, we can pull both the edited text and the, let's call it, newest text, and we can do a side-by-side comparison on that. You can also do that with like the deleted material. So with iOS 16, Apple rolled out kind of the concept of a recycle bin for your text messages. So we can do the same thing. We can be analyzing what that deleted message was, where it was in the chain, and be able to identify those so that if we wanted to filter on, hey, what were the edited messages, we can jump to those quickly. We can compare what's been deleted. So there are some ways
And
to do
then
that.
what collection method would you need? And then we'll get this question. What collection method would you need of our list to be able to see edited messages?
So let's look at full file system, logical, targeted being kind of deeper dives. You can do that with all of those. I think.
What about cloud?
On the cloud?
Like an iCloud?
So I would have to tag in Ryan Fry on that.
Yeah, just a second. Before we go there, though, we need to be careful that not all applications, the application needs to be specifically designed to read these additional metadata fields. You know, people go out and go, oh, I bought this, $60 backup program for my iPhone. What's wrong with it? It's like, it requires specialized engineering to see those messages, to see that content, and to display it so that you know it's there. If you just do a read in from the iMessage database, not to get too in the weeds, you're not going to see that stuff,
Correct.
right?
Yeah, that's correct.
I mean, it takes a lot of extra engineering to take those extra steps to keep up with how Apple is changing the iOS and the messaging platforms. Otherwise, all you're going to do is just see the normal messages that would have been there. So,
Right.
sorry,
I hear about that a lot. The iOS
I wanted
matters.
to, yeah, it's just, it's a moving target, literally. It seems like.
And I think we have another question.
I have a question. Can you speak to understanding the engineering and the technical component to collections? Can you speak to the employee or the disgruntled employee and how that kind of dictates, the workflow in which you perform a forensic collection? Because there are different, caveats and workflows you can use to help ease the tension of, for instance, BYOD, their privacy concerns, right? And especially when you're dealing with, C-suite officials or senior management, that's more of a discussion, right? As opposed to someone who isn't as high up.
Well, so, yeah, some of the, this was kind of later in the conversation, but I think this is an appropriate place since you brought it up. We'll do it in context, right? Which is one of the things we're going to talk about, not too far from now, is something that happened in the last couple of years where if you don't have a functioning pass key, you're not going to get to that data once that phone sits there for more than 2 or 3 days or it reboots, right? We're going to talk about the 72-hour lockout later, but it's a good time to bring it up. If they're disgruntled, what's the chance they're going to actually give you a function? They're going to make sure that the passkey, what people are doing is grabbing a phone, sticking it in a box, sticking it in a locker in this case, and then thinking they're going to get to it 2 weeks, 2 months, or a year later, and it's not going to happen, right? The data is not going to happen. So I think that, as far as managing a disgruntled employee, I think that's going to come down to, what data are we collecting? Are you getting all their personal stuff, right? And that has to be managed. But from a workflow or forensic collection or backup process, you got to make sure you have a working passkey. That may sound simple, but it happens and it comes to bite people so many times as they just take it, they log it, they try to get into a phone later, and they can't touch it. They can't get to messages, can't get to contacts, and this was just something that Apple introduced about 2 years ago when Android copied it, was this extra security layer of if your phone sits there, if it reboots, you just can't get to that information.
And I know that that's something we're going to be talking about later about dealing with custodians and things like that. So let's quickly move through this. Cloud collection is data outside of the physical device. So that's going to be if you get something from iCloud, or if you're grabbing somebody's Facebook page from a Google, or doing a Google takeout for Gmail, or going outside the device to get things from the cloud. And this is more of a definition slide. And then self-collection, did you want to talk to us about that quickly, Michelle? And then we're going to move through.
Sure. I mean, self-collection is kind of what it sounds like. The user is the one collecting the data and providing it to counsel. Usually it involves taking some screenshots of messages or whatever's relevant on the device and forwarding those along. It's definitely like the lowest cost and least intrusive option, but it also carries like a huge risk of completeness. I mean, if anyone has ever tried to search for messages in their app and not been able to find one that you're specifically looking for, like I have, that's a clear example of like how you may not be able to find relevant messages.
It's problematic, but it happens, so we wanted to bring it up here. Now, preservation decisions in the mobile world, all right, we have preservation in place, preservation through collection, and hybrid approaches. Preservation in place can be very different with mobile. If you're preserving in place at a corporation with an entire IT department supervising it, that's a lot different from having somebody hold on to their phone. However, when you're dealing with many, many litigants and large mass torts, for example, and you may have thousands of litigants, preservation in place may be the only viable option, and the parties can discuss this, confer, and figure out the best way to handle that. Things could be different when things go to a bellwether in that particular situation, but there are times when preservation in place can be appropriate. Preservation through collection. Another aspect of preservation in place would be having a service provider hold the phone, but not yet collecting it to save the costs of collection. Preservation through collection, the safest method, and then there are hybrid approaches. So Michelle, can you talk to us about when collection is necessary to preserve?
Sure. I mean, it's generally the only way to really preserve a copy of all the information on the phone as it exists at that time. And given how portable mobile devices are and easily subject to be like damaged or lost or even stolen, the collection to preserve the information on the device really may be the most prudent course of action to ensure that the relevant data is being preserved. And it really may be necessary for like key custodians, especially if you know they have relevant data. But it's always going to depend on the facts of the case.
Okay. And then Sean, can you talk to us a little bit about starting broad and refining when you're looking at preservation?
Sure. So one of the things I love most about being in this room is that reasonable minds can totally disagree on this. But my take on this and what I see that work really, really well, at least in my practice, is you collect as much as you can. And then when it comes to your review and production stages, that's where you make the cuts. So, if we think about it in terms of the EDRM, there's a few steps in between collection, review, analysis, production, and I think it's important to treat those as separate things. And so I like to think of it as if I want to carve a statue, I want to make the statue of David, okay? I got to start with a complete block of marble, okay? Because sometimes you just don't know what's going to be there unless you look. I mean, that is a reality. We don't have a crystal ball as much as we would like one. And I think that, collecting pretty broadly to start and then refining it as time goes on, is a better way to do it. And frankly, it leaves options open. I've had a number of situations where all I need is text messages with this party, please produce them. Okay, done. Depositions happen. Hey, this person at their deposition said there's like 50 more people we need to think about. And so collecting up front in that way can make it a little more convenient when you have to come back to the well later on. That situation happens all the time, at least in my practice.
Great. So now we're going to get into some more in-depth analysis here. Now, Sean, you've already talked a lot about this topic with ubiquity of the data, everybody having it, meeting courtroom reality. Can you give us a little bit of some granular analysis of how things can be different, and then we're going to keep moving on because we have 10 minutes left.
I'm going to breeze through this really, really quickly, but everything that I do at my office, I'm always thinking about trial. What am I going to say? How am I going to explain this to somebody? And sometimes with mobile data, particularly the stuff that's kind of hidden, that isn't really part of the user experience, it can be a little hard to explain to a jury. Frankly, it can be hard to explain to the court what that is, what it means, what its significance is. And so this is one of those spots where, it's, again, something that's familiar to us. It's familiar to jurors, but it doesn't necessarily always translate well to the courtroom. And so I think this is, again, like I said before, one area where we can really be creative and where people in my shoes, the tech folks, get to be really creative too with the kinds of exhibits we make, the data that we rely on to make those exhibits, and how we present it and how we can make it click and make sense for people. Attorneys included, jurors included, courts included.
Okay, great. Now, during our planning sessions, Matt Rasmussen brought up this slide from Matt Mann, who's here in the audience today. And when we were talking about what you're seeing on your phone versus what you're seeing in evidence, Matt, can we get a microphone over to Matt Mann? Do we have one? And can you talk to us about this? It was in your lightning round, so just be real quick.
Real quick about evidence being static. That's what this is. This is a static point in time. So 2 years ago, if you did this today, those 4 images might be different. So it's important to know the source, the operating system at the time of collection, so you know what was received and what was sent at that time. So this is probably very different today if you pulled the same slide and I built it, which maybe I might do after this conference.
And it's the idea that what gets sent looks like a water gun and what gets received looks like a real gun. And there is that issue when you are expecting to see certain things as a user of a mobile device, which we all are, and the recipient could see something completely different, and that could impact your evidence. So moving on, John, what do you talk about with your clients, the attorneys that you're working with, the counsel that you're working with at the inception of a case when it comes to addressing mobile?
Yes, and I think that it applies and has for years is to why do we collect anything? Like what's on it that is relevant instead of just going out and assuming something's on it, what do you specifically have in mind? So it's about scope. It's about, okay, what specifically is on that mobile device that potentially will be relevant? Do you have, are there known messages? Are there call logs, contacts? Are there voicemails, voice notes? And so I think it really just comes down to investigating it. It's all about proportionality. We don't want to go blindly image dozens of computers if there's not a reason. Same thing with phones. It can get very expensive. It can be complicated. There's a lot to making sure that works, that works well and it flows well. And so it's really just a matter of what are you looking for and is it actually on those devices?
Okay, great. Now, our next slide is scoping mobile discovery up front. So, Michelle, can you run us through a couple of these?
Sure. So for mobile devices, scoping really starts with identifying who the relevant mobile data custodians are. You're going to want to assess that and also what types of devices they were using. Are they company issued or BYOD devices? What applications are likely to contain responsive data? What the relevant time period is, and also whether the company is using mobile device management or access management tools, what they cover, what the retention and syncing periods on the device are, and also like any backups that may exist. And that all really starts with talking to people. Custodian interviews with the client, with the custodians, may involve written questionnaires, interviews with company IT personnel, and I'm going to talk about that a little bit more in a minute, but that's kind of the sort of overarching initial.
Go ahead and talk about it now. We're running out of time, and I'm going to skip these next few slides.
Problem. So like beyond sort of initial inquiries, you definitely want to do some more digging to kind of verify what everyone's telling you, right? Memories are not always perfect. People may want to maybe just quite frankly brush you off because they don't want to deal with it, or they just simply don't remember. But it's really important to do some investigation to verify that you've adequately identified the who, the what, and the where, who the relevant custodians are, and their relevant devices, what the relevant platforms and applications on those devices are, and then where best to locate that data. Is it on the phone? Is it in the cloud? Is it on a backup or a third-party server? And then there's some steps that you can do. You can give out written questionnaires that ask more verifiable, objective type questions, like not just is there relevant information on your phone, but what are all the phone numbers of your devices? What are the make and models of your devices? What messaging applications are on your devices? Information that can actually be checked and verified. It may also, involve a little bit more independent work, such as video conferencing with people and screen sharing to walk through what's actually on the phone, confirm what's there, and check and verify the information. You may find things that hadn't been previously identified, not for any malicious reason, but just because it was overlooked inadvertently. But it's a way of testing and verifying what exists. You can also provide some targeted instructions to the people to kind of do those steps and send you the information so that you can also verify it. And then maybe you also sample some actual devices to really kind of test and confirm what's there. Run your own searches and just do some digging. But you have to do some more independent investigation. You can't just sort of rely on the custodians and that initial inquiry and let it be. That's not going to be sufficient in most cases.
Other panelists, anything you want to say about this slide before we skip ahead?
No, go ahead.
Okay.
She did a great job.
She did a great job. Thank you, Michelle. What I wanted to skip ahead to is this slide, the great debate, full file system versus targeted collection. Sean and John, take it away, and the rest of our panelists feel free to intermix your comments.
So the great debate is very easy because we don't like each other very much, so it might get really ugly up here in a minute.
That's not true. No, and as a matter of fact, we were just going to mention, it is kind of framed here in kind of an adversarial way. I mean, we literally have a versus in the middle of it, but that's just not really the case. No. And John and I actually agree quite a bit on the fact that both of these methodologies are appropriate in different circumstances. Yeah. Okay, not every case is the same. The methodologies that you're going to use for collecting mobile data are not always going to be the same. It's going to be tailored to and in tune with what kind of factual circumstances you're dealing with.
So since in the interest of time, we're just going to get through a few of the key points, And so as far as, if you look at the slide, you can look at it later, we talked about it a little bit earlier, is the idea of imaging really doesn't exist and what's logical versus, and we kind of covered that earlier when I talked about logical and you just, talked about FFS. So I think to add to that, is just to reiterate, because that's helpful, right, at times, is what is appropriate when and try to sum it up. We're on the same page, and as far as what are you going after, what's the scope, what data do you really need access to? So on the quote logical side, it's you need messages and contacts and call logs and data and voicemail, and you don't need to go after and try to deep dive recover. Then, here's the debate part. Here's the debate part. The logical and the targeted is always better. I don't know what you're talking about, Sean. I think you're just over collecting everything, but you can pull up the other side of that, which you've already stated, all the reasons that a full file system collection is appropriate.
Right, yeah, and I'm not going to rehash everything I said before, but there is additional information that you can get with a full file system extraction. And if you are not sure, if you don't know what direction a case is going to take, okay, if you don't know if you're going to have depositions that are going to change the entire ballgame as far as what's in scope, it can never hurt to obtain a full file system extraction. If you choose anything else, my position is there's always at least a little bit of a risk that you might not have collected it. And so, yes, there are some trade-offs. I think with full file system, being all cards on the table, it's not always the most convenient thing. I need physical access to it for about 4 to 8 hours. That kind of can be inconvenient for people, and I completely understand that. I need physical access to it, so either it needs to come to me or I need to go to it, which can, frankly, be expensive after expenses. I think that it's not totally without its warts. There's definitely a time and a place for both, but in my view, when in doubt, full file system.
But it really comes down to, just real quick, it is a cost factor. Just like I used to be a forensic guy in the field, collect imaging hard drives. They paid me. They had to pay expenses. They had to pay go on site. I had to pull the hard drive out, make a copy, and then all of a sudden they realized all I needed was their My Documents folder. That's why scope is important. The biggest differences are the expertise of the people doing it. If you're doing a logical collection, you can remotely download software, screen share on their phone or their computer, and walk them through it, and it's defensible, and you have a chain of custody. That's a lot cheaper than full file system, but it takes a whole nother expertise, and I think that's the biggest takeaway from this. Both have their place, but make sure you know what place that is, because if you don't need it and you spent the money and you spent the time, people may not be happy about
we
that.
have a question, and we've got 1 minute, so.
Okay. But online is asking, you've got some fantastic slides, if they're going to be available as part of the materials.
Yes, they are.
Okay.
Yes, they are.
And then the question is on if you have an app that like Signal that advertises itself to be, I guess encrypted.
Disappearing ephemeral, yes.
Yeah, and ephemeral, whether you still can collect that in any circumstances.
It is gone.
Yeah, I can take that. If you have any chance of getting anything from Signal, you really need to do an
You need a
FFS.
full file system.
Yes, that is
You
true.
don't really have a choice, number one. And number two, even if you have disappearing messages, I mentioned the example of a case in Minnesota. Just because it was automatically disappearing, it automatically deleted, I was still able to find it in its entirety in a separate database somewhere else on the phone. So it's not impossible. Again, you don't know unless you look.
Can we have 30 seconds?
30 seconds.
Okay. I don't know if we featured enough of the targeted collection side of things. So just Matt, John, real quick, starting with Matt, give me a couple of, real quick on a targeted, why to do it.
I think it just comes down to reasonableness and proportionality, right? Like we were talking about, we're building a custom car for every matter we're doing. There's a different tool set for what we need. But if we can define those things early and we can bring in the right tech solution to do those things should be considered. But there's like, we could go on for 3 hours about this for sure.
Right.
It's asking those questions early, knowing which direction you want to be heading, and then making the right technology kind of decisions is the right kind of decision tree to be making.
And then, John, just real quick, a quick example of when targeted collection was the right fit.
Yeah, just 2 weeks ago, we had everybody decide, there were 2 Android phones, everybody decided these are the numbers, absolutely the numbers, we don't need to do anything else. We were able to help a client collect 2 Android phones in less than 10 minutes and update it, and the attorneys had access to it literally within the hour. And if you can do that with your scope, it can save tons of time and tons of money and be there for review quicker.
And then Michelle, just 10 seconds, last thoughts.
Yeah, sure. I think it's really important just to make sure you thoroughly investigate and follow up on preservation and scope to make sure you've adequately identified the data.
Great. And Sean, thank you so much for all of your contributions to the panel.
Suzanne is amazing, by the way. She did a great job.
Thank you very much, Suzanne.